Greetings to all. Myself Dr. Soma Anil Mishra, and I will be speaking about professional practice in architecture, which is used in architectural practice all over India, and that is governed by the Architects Act 1972. And I am from architecture department, and will be delivering the lecture on how the professional practice should be adopted in architecture profession when one passes out with the degree of B.Arch. This is the Architects Act 1972. It is the bill passed by Government of India, and accordingly we all architects, we have to follow these rules and regulations as given by the Government of India according to Architects Act 1972. Everybody must know this act, whosoever passes architecture 5 years course, even if that person is into academics or into practice, they have to follow Architects Act 1972. So, actually what is it? When you do the degree, then you become an architect, and it is written in the register in the Architects Act 1972 that who can use this title architect. The person who has done a 5 years degree in architecture can go for registration in the Council of Architecture. Then one goes to the Council of Architecture and gets his or her name registered in the list, and then he can be called himself as an architect. Just after passing out, nobody can be called as an architect. The name of that person should be registered in the register of Council of Architecture, and that comes under section 37. And the prohibition does not affect, otherwise actually no people other than architects can use this term architect. Nobody can write architect in front of their name. It is passed by the Government of India at Act 1972. But the people who have done naval architecture or landscape architecture, they can also use this title without doing B.Arch 5 years degree. There is integrated course, and they can directly do that course, and they can be called as the landscape architect or the naval architect. Then the contravention will lead to imprisonment, fine, or both. It is there in Architects Act 1972 that if a person who is not an architect, who has not done a full time 5 years degree, or maybe naval architecture or landscape architecture, and then he is using the name architect, the title architect, then he can be imprisoned, or he can be fined, or both can be implemented on him. The main purpose of the act is, as given in the preamble, is to provide for registration of the architects. So that actually earlier what happened is there were so many people who were working and practicing as architects, but their names were not registered in one single place with the Government of India. So, that is why the major purpose, the starting of the purpose is to maintain a proper register, so that name of all the architects are there in that register. That is the major purpose. It contains 45 sections and along with one schedule also. The act can briefly be studied under following heads. There are various heads under which the act can be studied. The first thing is the architect. Then now what is the need of the act? Why the need arose so that the people had to make the act? First thing is the architects' professional conduct regulations are primarily for the guidance of the architects, so that the architects, they come to know what we should do, what we should not do, and the common public, the citizens of our country, they come to know about the architecture profession, and they should know the do's and don'ts of architecture profession also. Architects' attention is also invited to the guidelines for architectural competition, which must be compiled with COA. Like the people who want to go for competition, means the architects who want to compete with other architects, for them also the guidelines are given very properly with the Council of Architecture, so that they follow those terms and conditions while going for the competition. Professional services is essentially a personal, but the comprehensive responsibilities are often fulfilled in cooperation with members of other profession. Means the professional services, if you are an architect, then the professional services which you will be given to the people, that will be your personal thing, but you have certain comprehensive duties with the people, the other people who will be practicing with you, maybe the structural consultant, the surveyor, the mechanical engineers, the fire safety engineers, and the society, the citizens of the people. So, these are your comprehensive responsibilities, so that you know that whatever you do, that is not going to benefit or harm yourself, it can harm the society or the professionals and people who will be working with you. What are the then functions of the Council of Architecture? Functions are, the Act provides for the establishment for the Council of Architecture, a body consisting of members from institutions, councils, central and state government nominee. Actually, when the Council of Architecture is formed, they have certain members, 5 members, and the members, they are from different bodies, and there are some are from the heads of the institutes also, and the from the council, then from the IIA, and the central and state government also nominates certain IAS and IPS officers. So, this forms the major governing body of the Council of Architecture. It appoints the registrar, one full time registrar has to be appointed in the Council of Architecture for the maintaining their office. Then it can remove the name of architect from the register, either on his own application, or if the person has done something wrong, then also the name of that person can be removed from the register, and that the Council of Architecture has the full rights. If somebody sues a certain person and so that person has done something wrong, then the name of that person can be removed, and when you do the degree, you have done you have got all the 10 mark sheets of 5 years, and then you can go for registration. This is registration. So, the council has the right to write your name in the register and also to remove your name from the register. To maintain proper account of finance, because the Council of Architecture, it has the duty of looking after the colleges and the institutions which are going on in the country. So, for that the institutions, they fill the form and they have to pay a certain amount to the council. Then the people who do registration, they also pay a registration amount to the council. So, and when people go for competitions, then also an amount is paid. For arbitration, people have to pay to Council of Architecture. So, it has various sources from where the money is collected. So, it is the responsibility and duty of Council of Architecture that they maintain proper finance register, because anybody, any architect has the right to go for right to information and see whether the finances are maintained properly or not. To inquire into matters relating to misconduct. If somebody has done misconduct and the other person has sued him, then the Council of Architecture, it will not blindly obey, blindly listen to that person and consider that that person has done something wrong. It is their duty to go and check whether that particular misconduct has really happened or not. Then the council is very powerful. As far as our profession, the architecture profession is concerned, the most powerful body of the India, of our country, is Council of Architecture. It has the power to acquire, hold and dispose the movable and immovable property. If actually the construction has been done in some illegal way, or the architect has not followed certain norms and conditions, then somebody has sued and has gone to appeal to the Council of Architecture, then the Council of Architecture has the power to acquire that particular property, even if it is movable or immovable property. The council has the power to enter into contract also, and the council can sue you also. It is not necessary that other person, other architect or the person from society can sue us. The Council of Architecture can also sue us, and we can also sue Council of Architecture. They can be sued also. It has the power to appoint inspectors to inspect any architecture college. When we go for, like we have our architectural institution, we fill the form, then the Council of Architecture sends people to our college to do proper inspection, whether the course is run properly or not, whether the faculty members are properly qualified or not, and well, so many things, the infrastructure and everything. So, the Council of Architecture can it has to send the inspectors to colleges to inspect whether the things are going on properly or not. Powers to make regulations to prescribe standards of professional conduct and etiquettes and code of ethics. These code of ethics, these were primarily made in 1972, the act came, and in 1989 the regulations have been made. So, there are the regulations are written there only, but the council has the power to maintain it. Actually, they can remove certain rules and they can add certain rules also. So, this comes under the power of Council of Architecture. Then I will be telling you about arbitration. When this was Council of Architecture, under Council of Architecture Act 1972, certain things are given, and then now suppose there are two people and they don't agree among themselves. They have certain a certain level of maybe disbelief, or maybe a person thinks that the other person has done something wrong. So, then that is considered, and that comes under arbitration. So, what is arbitration? Arbitration, it is happening in our society since ages. Like two people, if they have a fight or some kind of disbelief or some kind of maybe mistrust in the other person, then what we do? We go to a person who may be a better person than us, maybe in age, maybe in experience, maybe in qualification. So, in villages what used to happen, that people used to go to the sarpanch, and if suppose there is a small thing, then if two people, two neighbors, they fight, then there is a person from the society, we call that person and you tell whether who is correct. This is known as arbitration. Arbitration is when there is some disagreement between two parties and they do not go to the court, they can go to certain person, so that they can who can solve their problem, and this process is known as arbitration. Arbitration, it is so this I told you, like it is one of the oldest form of solving any dispute without going to the court, and there is a third party is called the person who is more qualified than us or maybe more experienced than us. So, we call that person to solve our dispute. It is one of the most popular mode of settlement of dispute relating to building and engineering contract. In building and engineering contract, what happens is, if a person goes to court, then it may take months or maybe years and so much of time. So, it is better to go for Council of Architecture arbitration, so that we know that our problem will be solved by a qualified architect and who knows the do's and don'ts of our profession. So, it is an easy way out. Then instead of litigating the matter in the usual way through courts, it saves time and experience also, and it also avoids unnecessary technical and unnecessary technical liabilities, unnecessary technical writings and logistics. It saves in the logistics to a large extent. Then when one goes for arbitration, then he has to have proper paper written and proper written documents, that is known as arbitration agreement. Both the parties, they have to agree upon a certain thing, like this is something wrong which has happened and we want to take the suggestion from a third party. Okay. So, this is known as arbitration agreement. It means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship with contract or not, a non-contractual legal relationship. It can be a legal relationship, it can be non-contractual legal relationship also. What is contractual legal relationship? It is when the party, one architect and the client, they go into certain agreement, they start a project. So, there is an agreement, but if the neighbor is not satisfied with whatever this architect is doing, so you do not have any written or legal contract with your neighbor, right. So, in that case, that is known as a non-contractual legal relationship. So, this type of a legal or the non-contractual legal relationship also can be taken to the agreement, even if we do not have written paper or agreement. Okay. Then what are the essentials of arbitration agreement? A document signed by the parties. First thing is there should be a proper document which should be signed by both the parties. Both the parties should agree that okay, something has happened and we need a judgment in that. Then an exchange of letters, telex, telegrams or emails. There should be proof, like means in an instance one person should not go for arbitration. Initially there should be some talks happening, some WhatsApp messages, some emails, those are also considered legal, or other means of telecommunication providing actually the record of agreement, like how the people have reached to this stage of arbitration, those things should be recorded. Suddenly a person cannot go for arbitration, there should be certain talks, certain dialogues between them, and it should prove how they have reached to this thing, then it goes for arbitration. The document containing an arbitration clause may be adopted by reference by a contract in writing. It should be, it can be in a stamp paper, actually it is a legal document and it should be properly documented in a contract in writing. It should be in the form of an arbitration clause in a contract, or it may be in the form of separate agreement. This means that if the arbitration clause should be mentioned in the contract when the person is going into contract, like if this is in case of legal contractual agreement, means agreement between the architect and the contractor, architect and the client. So, this type of thing it should be written in the contract, and if it is between the neighbors, then it cannot, you will not have any proof like this thing is written in the contract. Means when the person of the same party, like the same project is going on and the architect and the client, or the architect and the contractor, if they want to go for arbitration, then it is better that in the earlier stage when they are going for contract, it should be mentioned, they should try to mention it in their contract. There are certain advantages and disadvantages of arbitration. Advantage first is arbitration is often faster than litigation in court. This is one advantage. And what is the disadvantage? It is arbitration may be subject to pressures from powerful law firms representing stronger and wealthier party. This can happen, like the arbitrator can be in influence of some stronger or the powerful party, may be financially stronger, may be politically stronger. This can happen, there is a possibility. So, this is one disadvantage. Simplicity of procedure, this is one advantage, that this procedure is very simple. Then the disadvantage is, if the arbitration is mandatory in binding, the parties waive their rights to access the courts and to have a judge or jury decide the case. It happens in many cases that if the arbitration is binding in the contract, it is good in one sense, but it is bad also in the other sense, because the people, they try to cross that stage of arbitration and go to the courts. Okay. Then next advantage is avoidance of delay and uncertainty involved in appeals, like there are various stages in court, and and it is time consuming also for going for appeals again and again. This is overtaken by the arbitration. Reduction of expenses in most cases. In most of the cases, arbitration costs much lesser than the the litigations of court. Then one disadvantage, in some arbitration agreements, the parties are required to pay for the arbitrators, which adds an additional layer of legal cost that can be prohibitive, especially in small consumer disputes. Like one thing, it is said, it is written in the arbitration clause that it has to be mentioned in the contract. So, suppose the project is very small, then this arbitration clause, and maybe they never go for any kind of disagreement. So, in that case, the arbitration costs, arbitration cost is unnecessarily added in the cost of the project. So, this is one negative aspect. Then one positive aspect is saving of time, appointment of a person having required technical knowledge. Like in the court, the judges and the lawyers, we do not know they are from which profession, like means basic their basic qualifications we do not know, and maybe they are not architects. So, it is sometimes it is difficult for the to reach to certain solution and reach to certain judgment unbiased. There is no jury, and from the claimant's point of view that may be a serious drawback. This can be a serious drawback, like there is no jury. This is one negative aspect of arbitration, that there is no jury. So, in certain cases it can lead to a serious drawback, and then maybe later on the person has to go for the court decisions. Then arbitration is a domestic forum. It is not a legal or the government forum, it is a domestic forum. It can be solved within the neighbors, and it can be solved in a peaceful manner. It is a forum other than a court of law or determination of disputes and differences after hearing both the sides in a judicial manner. The arbitrator, he has to listen to both the sides in a judicial manner and has to give the decision. Arbitrator, who can be an arbitrator? Arbitrator, a person who is appointed to determine differences and disputes, is called an arbitrator. The proceedings before him is called the arbitration proceedings. Whatever paperwork is submitted to that person explaining how the people have reached to the disagreement, those papers are known as the arbitration proceedings. Then these are certain objectives of arbitration as per Council of Architecture: to comprehensively cover domestic and international arbitration in conciliation. Then to ensure that arbitral award is enforced in similar manner as degree of the court. Like when the person gets the certain decision is given, it should be in a similar format. This should be taken care by the arbitrators. To ensure that settlement agreements of parties will have the same status as that of award of degrees. After settlement, the parties, it should not happen like there should be some fight among themselves, and means there should not be any kind of disagreement left after the arbitration is done. To ensure that supervisory and interventional are minimized. It is to be ensured by the arbitration team, the arbitrator and the people who are there, that there should not be any interference from the fourth party. Third party is already there, there are two parties and there is one arbitrator. There should not be interference from somebody who may be influencing one party or the other. Means the crux is that the judgments should be unbiased. To make provision for an arbitral procedure which is fair, efficient and capable of meeting all the conditions, all the terms and conditions. There are some major other objectives also: to permit an arbitral tribunal to use mediation, conciliation or other procedures during the arbitral proceedings to encourage settlement of disputes, and to provide that the settlement agreement reached by the parties as a result of conciliation proceedings will have the same status and effect as an arbitral award and degree and the agreement. Then how the arbitrator is appointed? In case of sole arbitrator, by the agreement, if there is one arbitrator, it can happen that both the parties, they agree upon a certain arbitrator and they think that okay, this person can be our arbitrator. In case of two arbitrators, each party will appoint one arbitrator from their side. Okay, this also happens, like there can be two arbitrators also. The parties can agree on a procedure for appointing the arbitrator or arbitrators. It is upon the parties, like they agree how many arbitrators have to be appointed and who will be their arbitrator. Party can request Chief Justice to appoint an arbitrator. This also can happen, like the arbitrator can be Chief Justice means of the arbitration body only. Suppose there are 2 arbitrators from one party, 2 from one party, then there will be one chief person who will be not biased and who is not known to both the parties. So, that person is known as the Chief Justice. Then the powers of arbitrator to accept the appointment in writing, they have to, the appointment is given and the things are written in the stamp paper, then the arbitrator has to accept the appointment, he has to say in writing that okay, I accept this arbitration. To study the submission of arbitration properly, to give proper notice of meetings, he has to, because once he takes the case like I'll be the arbitrator, then after that he has to give notice to both the parties. So, like you have to, these are the things, and now come and we'll decide, we'll discuss upon it, and I'll reach to certain conclusion, then that what should be the result. To avoid communicating in private with any party or any other witnesses. It is important and it is legal that he cannot communicate with any party personally, he should not, because then he will be biased and he may take decisions which are suitable to one party. To set the procedure, mode of presentation by parties, time and place of meeting as required. He has to send a common notice and refer to both the parties, so that the notices reach to those persons, and in that what should be written? The place and time of their meeting, where the things will be decided. So, these were the my presentation. It was about Council of Architecture, and then Council of Architecture tells you what should you do, what you should not do, and if certain people they disagree and they do not agree to the Council of Architecture and they do not fulfill the norms as per Council of Architecture, then the person is free to go for arbitration. These are the references which the books I have referred. It is Roshan Namawati's book, then Professor Apte's book, then H. Turner's book, and then Council of Architecture's handbook. You can directly go to the Government of India www.coa.gov.in, and everything is given in the Council of Architecture handbook. So, I explained about that only. Thank you very much.